Thank you for joining today's Technology Transactions webinar. Our program today will focus on optimizing dispute clauses in technology transactions. My name is Brad Peterson, and I'm delighted to introduce today's program. I lead our global technology transactions practice, which has 50 lawyers around the globe specializing in data, digital, outsourcing, and software transactions. We are focused on the digital transformation made possible by automation, artificial intelligence, and robotics. Dispute resolution clauses are, of course, critical in all of our agreements, and so I'm delighted to today have three of our leading technology transactions litigators with me to talk about this important topic. I will cover a few administrative matters, and then we'll get started. First, at the bottom of your screen, you will notice that there are multiple application widgets that you can use. Answers to some of the common technical questions are located in the Help widget. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or browser sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off of your VPN or Citrix connection is recommended. If you are applying for CLE credit, you will need to record the alphanumeric code provided during the program on the affirmation form found in the Resource List widget. Also, in the Resource List widget is a PDF of today's slide deck. This webinar is being recorded, as we normally do with these programs. In a day or so, we will be sending you an email with a link which you can use to listen to the webinar again or share it with your colleagues. The recording will also be posted to our website at www.mayerbrown.com. Look for technology transactions. Finally, we plan to allow time during the program for questions. To submit a question electronically, please use the Q&A widget. If we don't get to your question during this webinar, we will make every effort to follow up with you afterwards. So with that, I'm pleased to introduce my colleagues speaking on today's webinar, Jim Ferguson, Sarah Reynolds, and Miles Robinson. Jim Ferguson, a partner in our Chicago office, is a litigator who focuses his practice on complex commercial litigation and U.S. and international arbitration, particularly in matters involving intellectual property or information technology disputes. Sarah Reynolds is a partner in our Palo Alto office. As an integral member of Mayer Brown's international arbitration practice, she represents technology and pharmaceutical companies in international and domestic arbitration, including JAMS, AAA, ICC, ICDR, and SAIC. Those disputes involve, among other things, complex commercial supply, licensing, and outsourcing agreements. Sarah is a Center for Conflict Resolution Certified Mediator and a fellow of the Chartered Institute of Arbitrators. Finally, Miles Robinson is a partner in the London office of Mayer Brown's litigation and dispute resolution practice, having joined Mayer Brown in 1966. He represents clients in substantial contract and commercial claims, often with a cross-border element. In the technology space specifically, Miles has extensive experience on advising on matters that commonly arise in a technology or outsourcing relationship, such as material breach, termination rights, limitations of liability, scope of license coverage, software audit rights, software performance issues, fail to meet service levels, and other targets. Miles has also advised on software testing and acceptance procedures, the definition of the scope of services, and strategies involving the use of step-in rights. With those brief introductions, let's get started with today's, let's get started by talking about the agenda for today's program. What we'd like to do is start by talking about the common areas of dispute, then talk about options that you have in dispute resolution clauses generally. We'll then dive into the question of arbitration versus litigation and go into a deep dive on an arbitration clause checklist and compare some of the benefits and risks in different approaches to governance provisions. At the end, we'll talk a bit about overall principles that you can derive from this webinar and minimizing the risk of disputes when drafting technology transactions agreements. So with that, Miles, could you start us off with a description of the common areas of dispute and why they happen.
Thanks, Brad. Actually, I joined Mayer Brown in 1996, not 1966, so I don't have quite much experience. So historically, more of the disputes with which I've been involved have been on the customer side rather than the supplier side. So my comments may contain an element of bias towards acting on that side of the fence. I should also say, as an English lawyer, my perspective is influenced by how English law and practice works, although I think the overall themes that I cover are relatively consistent across jurisdictions. So with those caveats, I'll move to the first of my slides. Here I've pulled together some common themes for causes of disputes in technology contracts, particularly in complex outsourcing relationships, but also in more straightforward software procurement and implementation contracts. This list is not by any means comprehensive, but it should give a flavour of what we see in practice. Given the nature of these transactions, particularly the larger scale ones, it's inevitable that there will be disagreements along the way. Our experience is that how they are handled from the outset will often determine whether or not a disagreement turns into a dispute that disrupts or damages the relationship. So turning now to the common causes of disputes, the points on this slide arise from commercial aspects of the deal. First cause I've mentioned is that the deal structure is too one-sided. So while achieving a great price or a great deal on price, scope or implementation timescale might be beneficial and look good internally in the short term, this can store up significant problems for the future. If a deal is too marginal, it can very easily slip into a negative situation where either party is needing to cut corners or be aggressive in their interpretation of responsibilities. This inevitably leads to disputes and, more broadly, a relationship where incentives are not aligned. Similarly, when a deal is signed, all concerned generally want to implement it as soon as possible. If, however, the timetable is unrealistic, that doesn't benefit either party. It can lead to a lack of confidence in the project from the business. It can take longer to reach the point at which anticipated savings are achieved and can generally just set the project off on the wrong foot. Also, depending on how the contract is drafted, a failure to hit initial milestones could even lead to termination rights being exercised and the contract being ended at a much earlier stage than envisaged. The final point on this slide is more one of expectation setting internally. The way in which a deal is sold internally can have a significant effect on its success in the long term. Inevitably, assumptions are made at the outset that the contract will proceed smoothly, with financial projections that reflect this. If those projections are not met, this puts the deal under pressure and can make it more marginal. Care should be taken, in our view, to build in some contingency for the likelihood that not everything will go smoothly. Moving to the next slide. This slide addresses some contractual issues which we see give rise to disputes. They're all reasonably obvious, but there are just two that I'd like to highlight particularly. The first one is the second one mentioned on the slide, which is the temptation to agree to negotiate details at a later stage. This can be an attractive option in terms of getting over bumps in the road in the negotiation and kicking the can down the road, and it may well be unavoidable in some instances. But in our experience, it's a very common cause of disputes and delays, particularly where there's not an effective process to resolve an inability to agree the necessary details, such as having a default position or having one party or the other party able to determine what the position should be. Second point to highlight is the final one on the slide. Again, it's tempting, particularly at the beginning of the relationship, to let minor issues slide. In our experience, this can be counterproductive in that it can store up problems later and set the wrong tone for the relationship. The dispute resolution provisions are often heavily negotiated, but they're there to be used, and they can, if used properly, can enhance rather than damage a relationship. This is a theme that we'll develop later in the course of this presentation. On this next slide, we've outlined some general characteristics of technology-related disputes. Again, these are general themes based on our experience, and it's certainly not intended to be a comprehensive list. First characteristic is that they tend to be high stakes and high value, often reflecting the fact that these are high value and important underlying contracts. They also tend to involve matters of critical importance to the customer's business, assuming it's business critical technology, and indeed often where it isn't business critical technology, given how interconnected technology systems can be. Third characteristic is a difficulty in working out who is actually at fault for an issue. This is particularly prevalent during an implementation phase, where there are numerous interdependencies in terms of obligations to provide information or provide approval for designs and similar types of activity. There's certainly the risk at the implementation stage that design responsibility in particular can become blurred. Understandably, the desire to get the project done means that it becomes more of a team effort across customer and supplier, which can make establishing fault very difficult if something goes wrong. The final characteristic that we've listed is an indication of why we don't tend to see that many technology disputes progress to formal legal proceedings, whether that's litigation or arbitration. Because of some of the factors that we've mentioned, there are often very strong commercial incentives on both sides to ensure disputes are resolved rather than fought. This means that often, even though it may not seem to be the case, actually incentives for ensuring resolution are aligned, and this can mean that sensible use of the dispute resolution provisions can tease that out and provide a route for the parties to find a resolution without either of them seeming to back down. So I will now hand over to Jim Ferguson, who's going to focus more on the sorts of disputes that he sees on the IP side.
Thanks, Miles. Many, if not most, tech transactions involve some form of intellectual property. In many cases, for example, the transaction will involve a license to use existing IP, such as a software or source code license, or a license to use patent rights, or trade secrets, or non-public know-how. In still other cases, the transaction will focus on the development of new intellectual property, which is true of many joint ventures and other collaborative arrangements, such as those involving, for example, artificial intelligence and robotics technologies. Given the importance of intellectual property to technology transactions, it's perhaps not surprising that when disputes do arise, they often involve intellectual property. And on this slide, we've highlighted the three categories of most likely intellectual property disputes arising from technology transactions. The first, of course, is royalty disputes, a claim by the IP-owning party that the other party has not paid the royalties that are due and owing under the agreement. A second category of IP disputes that arise in technology transactions involve claims of IP misuse. In other words, the IP owning party claims that the other party used the relevant intellectual property outside the scope of the license in ways that weren't contemplated or authorized by the license. And then the final category of IP disputes arising from technology transactions involves claims of IP misappropriation or IP ownership. In other words, the IP owning party will assert that the other party used its proprietary intellectual property in order to develop a new source code, new software, a new form of intellectual property, and therefore the original IP owner has a claim to it. So these are the common areas of dispute arising from technology transaction, and we try to identify why these disputes often arise. With that background, we're now ready to turn to our next section, which are different options for your dispute resolution clauses. And Brad, I'm going to turn the floor to you.
Thank you, Jim. So as Miles and Jim have pointed out, this is an enormously difficult area. And as Miles has said, we find ourselves knowing that we're moving into situations with blurred responsibility and a strong commercial desire to just get it done, and people jumping in and working in a team fashion, perhaps not even contemplated by the agreement. And that disputes are in some ways inevitable, and they should be handled in a way that enhances, not damages, the relationships, that build communication, build the personal relationships, and build the ongoing corporate relationships. So, what's been tried? In large-scale deals, the most business-friendly approach is the traditional tiered governance provisions. There's generally a governance schedule. It lays out the concept of an operational governance layer that might meet weekly and have perhaps designated people, key service provider personnel, focused on performance, on charges, on projects such as the implementation projects that Miles mentioned that often spring into disputes. Above that, there's a managerial level that meets monthly. These are people who are not on the ground working on the deal day to day, but oversee those people and are able from both companies to bring more perspective. And finally, there's an executive level that perhaps has a scheduled semi-annual meeting to discuss high-level relationship topics. Within that governance schedule, there will be a list of topics for escalation. So if the operational level is unable to resolve a topic, they bring it as it works within a corporate structure, bring it to higher level managers to see if that can be resolved at that level. And if necessary, those managers bring in the level above them. A different type of governance structure in the agreements, more formal and probably more common, is a formal provision that's called informal dispute resolution. Either party can highlight something as a dispute by notice that triggers a provision that might require both parties to provide a wide variety of information that might be somewhat like discovery. The provision may characterize that the information that's exchanged as provided in settlement or not available as evidence within a court. It, in some cases, prescribes set times for a first-level discussion among the group that manages the contract, followed by right of either party to escalate to named higher-level decision-makers. And those higher-level decision-makers might have a final escalation right. One of the key things about the informal dispute resolution process is that the provision often states that neither party can invoke any formal dispute resolution until the informal process has continued. And that means that it's designed to make sure that the relationship-oriented solutions happen before the legal solutions. Another approach, on perhaps a separate path, is to bring in one or more third-party experts. So if there's a dispute about a number, and what, for example, how much additional cost there is in the deal because of a change that the customer made, and thus how much the price should go up. You might bring it to a professional appraiser or estimator, or in some cases there are one chosen by the customer, one chosen by the supplier, and then one chosen by both of the professional appraisers. And the three of them get together and decide on what the right answer is. If those options fade, the agreements in some cases call for mediation, which carries forward the somewhat informal process, or litigation or arbitration. Further, of course, the most complex agreements have a collection of all of those components. And so with that, as a set of options, let's go into the more legal resolution piece, the piece about litigation and arbitration. And I'll hand it over to Sarah to talk about preliminary considerations in arbitration versus litigation.
Thanks, Brad. There are 8 factors that we think through at the deal stage when negotiating and drafting dispute clauses and deciding between litigation or arbitration. Each transaction should be evaluated, but as a general rule, when dealing with clients based in the United States, arbitration tends to win out on most factors. This is true in domestic deals, but is especially true in cross-border deals. Looking at those factors, let's start with neutrality. Arbitration is designed so that an impartial, independent, and neutral tribunal decides disputes. Arbitrations win with respect to neutrality, especially in cross-border deals. It allows clients to avoid being subject to foreign domestic courts, but even in the domestic context, many U.S. states have an elected judiciary, which almost certainly impacts neutrality in at least some circumstances. Looking now at confidentiality, there is sometimes a misconception that all arbitrations are confidential. That is generally not the default, but it can be if the parties agree to it. This is a point to consider when drafting clauses. Jim will talk more about that in a moment. So confidentiality is at least an option in arbitration. And while it's not bulletproof, for example, if domestic courts get involved in an effort to vacate an arbitration award, clients are better protected than in traditional litigation, where most, if not all, pleadings and orders are publicly filed. There may be instances where a client benefits from the threat of public litigation. For example, a fraud claim against a professional services company, where the threat of a public complaint might help induce settlement. But more often, our clients benefit from the greater protection from public disclosure that arbitration offers. This is especially true for disputes involving sensitive IP, know-how, source code, or other trade secrets. Looking next at ease of enforcement, clients often choose international arbitration because awards granted by an international arbitral tribunal may be enforced nearly worldwide through the New York Convention. That convention has been ratified by 158 countries. Taiwan is the often noted exception, and rests on 2 key principles. First, a written agreement to arbitrate is generally enforceable, and second, subject only to narrow exceptions, an arbitral award may be recognized and enforced as a final judgment in each contracting country. To enforce a foreign commercial arbitral award in the United States, assuming the losing party is subject to the jurisdiction of a U.S. court, an award holder need only present the award to the court, at which point it will be recognized and enforced unless the losing party can establish a basis for non-recognition under Article 5 of the New York Convention. There are 7 bases for non-recognition enumerated in Article 5. I won't go through them all, but to illustrate the serious procedural unfairness required, I'll give a couple of examples. Grounds include things like the arbitration agreement was invalid, or the losing party was not properly notified of the arbitral proceedings. I'll also note that the grounds enumerated in Article 5 of the New York Convention have been narrowly interpreted by U.S. courts. And the last factor noted on this slide, control over procedure. Arbitration affords parties the ability to choose either in advance in the dispute clause or when a dispute arises, either by agreement of the parties or via the discretion of the tribunal, the procedural rules that are to apply. Most arbitral procedural rules are more efficient than traditional court rules. For example, written discovery and depositions are rare, and document disclosure requirements are comparatively limited. Many institutions even include options for emergency and expedited procedure, and while there may be instances where a client would benefit from scorched earth discovery, more often our clients are trying to avoid that situation. Moving to the next slide, speed and cost. Arbitrations are not cheap, but they do provide parties with the tools to have a faster and less expensive proceeding. There are exceptions on both ends, but the rule of thumb is that commercial cases in traditional courts are resolved within 3 to 5 years, as where most arbitrations are resolved within 1 to 3 years. The reduced time spent in the dispute process almost certainly results in a comparative cost savings. The next factor has to do with the decision maker. Perhaps one of the greatest benefits in U.S. technology companies is that arbitration allows parties to a dispute to select a specialized decision maker, rather than being subjected to a generalist jury or a judge. You can choose decision makers with specific technical or scientific industry experience or educational background, and that can be critical to getting to the right result in a complex technology dispute. The next factor to consider are appellate options. If a client needs access to a clear appellate procedure or is looking to create legal precedent in a certain area of the law, this is one place where litigation might win out over arbitration. Absent that, though, appellate procedures add time and expense to the dispute process, as where, short of some limited quasi-appellate procedures available in some circumstances with some arbitral institutions, an arbitral award is final. One of the reasons I like the ICC, for example, as an arbitral institution is that there's an award scrutiny process baked into the administrative process, and that helps prevent errors in awards that you might otherwise need to rely on an appellate procedure to address. Along similar lines, the AAA and JAMS, among other institutions, offer opt-in appellate procedures that are quite strong. And the final risk factor is the risk of arbitrary results. There's endless research on the irrational and widely disparate results reached by U.S. juries and widespread concern among our clients related to juries deciding complex technology disputes. Going back to the ability to select your decision makers, arbitration affords clients a way to minimize the risk of irrational and arbitrary results. It's worth going through this analysis with each deal, but on balance, there are a few circumstances where arbitration isn't the better choice for most of our U.S. clients. The analysis is much the same for our non-U.S. clients, but for example, in the UK, where there are no juries and there are specialist judges, you may reach a different conclusion with respect to some of these factors. That said, the global enforcement point tends to carry the day for most of our clients, regardless of their location. And now I'll hand it back to Jim, who will talk about some of the technical issues and considerations when drafting arbitration clauses or other dispute clauses.
Thank you, Sarah. We're now going to move to what we refer to as an arbitration clause checklist, which is a very practical listing of the essential elements to be considered in drafting arbitration clauses for technology transactions. The first item on the checklist is what we describe as preconditions to arbitration, and what we mean by that are required steps to resolve the dispute using the relationship-oriented resolution techniques that Brad referred to earlier before the arbitration can be commenced. For example, a precondition clause could require the parties to engage in settlement discussion for at least 30 days after one party has served notice of the dispute before either party could file an arbitration demand. Or the parties could insist on mediation as a necessary step before commencing arbitration in a formal dispute resolution process. In this way, by careful drafting, the parties can fully explore all relationship-oriented steps to resolving the dispute before they have to resort to arbitration. The next three items all involve substantive and procedural rules that will be used in the arbitration. The selection of governing law, of course, is necessary to establish the substantive legal principles that the arbitrators will use to resolve the dispute. The seat or location of the arbitration is where the hearing, the actual evidentiary hearing, will take place. And the arbitral institution, the selection of the arbitral institution that will administer the arbitration, establishes the procedural rules. There are a wide range of very highly regarded institutions. We cited two here, the American Arbitration Association and the International Chamber of Commerce. And all of these arbitral administering institutions have procedural rules that are used by the parties. For example, they define how an arbitration demand or an arbitration answer is filed, and in some cases they also specify how the arbitrators for the specific dispute can be selected. Let's move now to number 5 on our arbitration checklist, the scope of arbitral disputes. This element is critical in any arbitration clause in a technology transactions setting because it will define exactly what disputes the arbitrator will decide. Most commonly, perhaps, the clause will specify that any and all disputes relating to the contract or the performance of the contract will be resolved through specified arbitration procedures, but there are other possibilities that should be considered, particularly in cases involving intellectual property. For example, the parties could agree to exclude from the scope of arbitral disputes certain types of controversies, for example, patent, on the theory that they want any patent dispute to be decided by courts that are specialized in dealing with patent disputes. Or alternatively, the clause may specify that the parties can apply to courts for equitable relief, specifically an injunction. This is very important in technology disputes involving intellectual property because it ensures that the intellectual property owner will be able to protect the property at issue if an injunctive relief becomes required. Number 6, the qualifications of the arbitrators. Several options here. One, of course, is to require expertise in the relevant technology or in the relevant area of dispute, for example, patents. Or, alternatively, the parties could agree simply to require an experienced arbitrator. As Sarah detailed earlier, there are a number of advantages arising from the ability of parties to select arbitrators with expertise in the relevant technical area. It perhaps can ensure that the right result is reached, but this is not always a open and shut question because there are other considerations. One consideration is that the number of relevant experts may be limited and may be subject to conflicts. And another consideration is that in many cases, individuals who have spent entire careers in a specific technical area, either in the law or in other areas of technology, may be locked into some very well-defined views on both technical and legal issues, and those views may not necessarily line up with your theory of the case. So this is a decision that must be made on a step-by-step and case-by-case basis, and it warrants important consideration. Number 7, the number of arbitrators. 2 choices here, a single arbitrator or 3. The conventional wisdom is that in major cases, the parties prefer 3 arbitrators as a hedge against an arbitrary decision. And in cases involving long-term agreements, joint ventures or other collaborations, for example, the parties often implement 2 types of proceedings, one for smaller disputes, less than a specific amount of dollars in controversy, that can be resolved very quickly, and then using 3 arbitrators for larger disputes. The thinking here is that the smaller disputes should not be given an opportunity to fester and perhaps mushroom and continue to damage the relationship. So if you establish a procedure for resolving these types of disputes as quickly as possible, that will enhance the preservation of the commercial relationship. Number 8, the selection of the arbitrators. This is critically important because the arbitrators are obviously the decision makers, and the decision makers, the identity of the decision makers can in some cases be outcome determinative. There are a number of possibilities here. We've selected only 3 leading. The first is the parties can agree to allow the arbitral institution, the AAA or the ICC, to select conflict-free neutrals. Another option is what's referred to as strike and rank. Unlike the selection of the arbitrators by the arbitral institution, the strike and rank option gives the parties input into the selection of the arbitrators. And the way that works is the arbitral institution will provide a list of 10 or 15 or 20 conflict-free neutrals. Each party will then have the opportunity to strike a certain number of the candidates, say 2 or 3, and then rank the remaining candidates in order of preference. The parties then submit their ordering, their ranking of the arbitrators or the candidates to the arbitral institution, neither one knowing what the other one has submitted, and the arbitral institution will select the 3 arbitrators that rank the highest in the combined pool. In this way, you get 3 arbitrators who are neutral. They don't know how the parties rank them or how they viewed them. And the parties at the same time will have some input into the selection of the arbitrators. And that leads me to the third category we've highlighted here, which is party-appointed arbitrators. In this arrangement, each party will select an arbitrator to sit on the panel, and then the 2 so-called wing arbitrators will select a chairman. Many companies, particularly in international arbitration, prefer party-appointed arbitrators because they want the comfort of knowing that there will be at least one arbitrator who will, if not necessarily adopt their views, at least articulate their views to the panel so that their views, their side, will get a fair airing. The next item on our arbitration clause checklist is confidentiality. As Sarah noted, confidentiality is an important consideration in many disputes arising from technology transactions, and all the more so if the disputes involve intellectual property, especially trade secrets. And so the confidentiality option is an important consideration. The parties can agree on the specific procedures that will be used in order to preserve confidentiality. For example, they can agree that they will return all discovery materials at the close of the hearing, the proceedings. They can agree that any transcripts of the proceedings and any award issued by the arbitrators will be protected by confidentiality provisions. Our last 2 items, scope of discovery and scope of remedies. With respect to scope of discovery, the parties have the option of defining how much discovery will be permitted in the proceeding, or they can leave the discovery issue to the discretion of the arbitrators. The parties can agree, for example, that there will be no depositions, that there will be only limited document production, or that there will be no so-called written discovery such as interrogatories, or they can leave these issues to the discretion of the arbitrators. This is another example of the advantages that arbitration offers to the parties to agree on the procedures that they will use to resolve their disputes. The final item on our checklist, number 11, the scope of remedies. In other words, what type of remedies can the arbitrators award? The parties can agree on this issue as well. They can leave the scope to the discretion of the arbitrators. They can bar certain types of damages, for example, punitive damages or consequential damages. They can bar or authorize attorney's fees. So in each of these ways, the parties in designing an arbitration clause have a great deal of latitude in putting in place a dispute resolution process that reflects their needs and interest. And this is one of the advantages, one of the many advantages that arbitration offers over other methods of dispute resolution. Having covered these essential items to be considered in any arbitration clause, we're now ready for the next section of our presentation, the benefits and risks in differing approaches to governance provisions. Miles?
Thanks, Jim. So some thoughts on how to approach disputes when they arise and how to fit those into the governance provisions that you have. I think as a starting point for any dispute, there are three things that certainly I would recommend doing when this comes across your desk. Absolutely critical to undertake an early investigation of the issue. This isn't because the dispute is necessarily ever likely to reach a court or a tribunal. It's because it helps you to establish one element of the negotiating position that you have with your counterparty. That's the legal merits. And also to help you decide how best to use the dispute resolution provisions that you have negotiated. The fact is that if you have been contacted by the business, they may over-egg the nature of the dispute, or their view may be coloured by frustration at how the other party are operating, without necessarily having absolutely got to the bottom of the facts. So by undertaking an early investigation, you may even decide that on reflection, you can advise the business that the dispute is not worth pursuing because the merits or the facts are against you, and it may in fact sour the relationship by raising a dispute that in fact isn't worth pursuing. So once you've established the facts and you understand the legal merits, that will help you to define your objectives. So what is it that you want from this dispute? What do you want to achieve? And do you have the legal merits and the facts behind you to help you do so? Various things that might cross your mind here. Do you want to use the dispute as a tool to obtain improved terms? Or more drastically, do you want to use it to help secure an exit from the relationship? Or do you just want compensation as a result of any damage that you have suffered? It may well be a combination of those objectives or something completely different. But once you have defined your objective, then I think that gives you a much better chance of working out what the strategy needs to be and how you're going to use the dispute resolution provisions to get you there. So Brad has talked about the various different types of dispute resolution provisions. I think whatever your provisions, as I mentioned earlier in the presentation, they are there as part of the contract in the same way as the confidentiality provisions are there as part of the contract, or the governance provisions, or anything else in the contract is just part of the contract. It's not a more important part of the contract. It's not a less important part of the contract. It's just part of the business as usual operation. It's not something to be wary of in terms of how these clauses operate. I think they can be seen as hostile. It can be seen as a hostile approach to invoke the dispute resolution provisions, but we absolutely don't see it in that way. If it's done in the right manner and with the right tone, they absolutely don't have to be seen as a declaration of war. Another important point to bear in mind is that they don't have to be seen as the start of a process, which will inevitably lead to litigation or arbitration and years of costly and disruptive procedures. The fact is that very few disputes that arise, frankly, whether in the technology space or elsewhere, reach the stage of formal legal proceedings. In our view, in these types of contracts, using the dispute resolution procedures, whatever they are, should be considered more as another part of your commercial toolkit, which can help you achieve the commercial objectives that the business has. We touched a little bit, particularly Jim has touched a little bit on not letting disputes fester and ways in which you can achieve that. Whatever your dispute resolution mechanism, whether that's multi-layered or whatever, or whether in fact you decide to go outside of the dispute resolution provisions and try and use a more informal method to try and sort out the particular issue that you're facing. Either way, that is far preferable in our view than allowing disputes to fester or ignoring them altogether. That kind of approach carries considerable risk in our experience. First, there's a legal point. The risk is that the ability to raise disputes and issues later can be compromised or lost if they are not raised in a timely fashion. The second and more commercial concern is that you risk, by not raising a dispute, perhaps for completely understandable relationship reasons, you in fact risk setting the wrong tone for the relationship. It can generate frustration on your own business's side because an issue is there and isn't being addressed, and it can also encourage a casual attitude to compliance with obligations from your contractual counterparty, neither of which is going to lead to a harmonious relationship long term. And in fact, as Jim has mentioned, that there are ways in which smaller disputes can be treated in a different way. Often it's very much beneficial to a relationship as a whole to ensure that those types of smaller disputes are resolved quickly and efficiently, even if the result isn't necessarily as favourable as you might want. At least there is a decision or a resolution. Long-running or unresolved disputes can be extremely corrosive to long-term contractual relationships. Finally, a note of caution about the sort of complex, multi-layered dispute resolution and governance provisions that we often see. They look great in theory and are often the product of a very well thought out approach and negotiation. But before agreeing to them, it is worth considering whether after the contract is entered into, the business has got the proper resource available to ensure that they are followed and they work. There is a real danger here of having governance provisions and dispute resolution provisions that are so complex that no one, in fact, has time to follow what is required. One example is where escalation provisions are left to senior executives who, in practice, have so many demands on their time that they don't have the resource and ability to focus on what is needed in the timescale needed, and that in itself can be damaging to the relationship as a whole. I'm going to hand back to Brad for the next section.
Thank you, Miles. I'd like to talk briefly about, from the perspective of a contracting lawyer, about how to minimize the risk of disputes when you're drafting contracts. And all of us who have worked in this area and have worked at the start of a contract and seen many go into litigation know that The question of whether you will wind up in litigation or wind up in a dispute is often decided based on the investment you put in the contracting phase and the investment that your client is willing to make into the contract. So we recommend that contracting parties be realistic about what it's going to take to manage this contract. And when I talked earlier about the various levels of governance and the number of conversations necessary to have a successful commercial resolution of the day-to-day differences that pop up, you can imagine that will require perhaps dedicated people in large contracts, a team of dedicated people to make that successful. As you're working through the contract, make the investment to actually agree. It's easy, particularly in the heat of negotiations, to kick the can down the road with some sort of agreement to agree, something like as the parties will determine in the future, or as may be agreed between the parties from time to time, or as requested and reasonably approved. But those are, in some ways, disputes waiting to happen. Resolve those disputes before they happen by having the right provisions in the contract. And then, while you're having the right provisions in the contract, make sure that when people say, we'll work that out through the relationship, that the relationship has a foundation where your client has adequate power and balance within that relationship to successfully resolve the dispute, even if the other party is more in a cram down mood. So from the customer side, we often say, well, have the right to take pieces out of the buy, a right to insource or to use other providers, have the right to withhold disputed charges so that the other party knows that it won't be paid until disputes are completed. Require the supplier to use the customer as a reference site so that there is some motivation to have a happy customer. Then, of course, the more specific provisions that you should build in. First, an effective dispute resolution provision. If there's one takeaway from this webinar, it's that these dispute resolution provisions, what a lot of people think of as just a piece of boilerplate, are actually a complex series of decisions that matter. Getting those decisions right will help. And then in the individual pieces, do what you can to position yourself to have an effective answer when a dispute arises. Make sure that it's clear when project milestone should be completed and what it means to have completion and what the consequences are if they're not completed. Address the consequences of various developments. And with that, we believe that you can have a much more effective and efficient relationship, one with a contract that supports the relationship instead of making it more difficult. So with that, question came in that I thought was very interesting. What trends do you see coming through in technology disputes in the short and medium term? And maybe just go through our presenters in their starting order. Miles, Sarah, Jim, can you each pick one trend?
Sure. So I think from my perspective, the trend that I've seen developing over the last year or so, and I think is only going to increase, is that of aggressive software audits by providers. It's probably driven by a number of factors, but my takeaway is that the technology sector is ever more competitive, and providers are aiming to get what they can from existing contracts and use them as a mechanism to drive extra business and tie in customers for longer. And that means that there is much closer scrutiny on whether customers are using the particular product in the way that has been agreed, or whether they have the right number of users plugged into the product, particularly with remote monitoring tools being very sophisticated. That's quite an easy way of the provider to come to the customer and say, look, we can tell you're not using the product in the way that you should be using it. That leads to significant potential claims. So I think that is a trend that is going to that we're going to see a lot more of over the next few years.
And this is Sarah. Another trend that I'll point out is that with a large number of force majeure notices that companies have issued in response to the COVID-19 pandemic, many of those disputes are arising over which party in the supply chain should bear losses. That's an issue that will affect a lot of our pharmaceutical clients as well as other technology clients. And some of these disputes will inevitably require the intervention of a neutral decision maker, an arbitrator. And there's a question as to whether or not the parties have to arbitrate such a conflict when one party's standard form contains an arbitration clause and the other does not. There's been some recent guidance on this from the United States Supreme Court. But when an arbitration clause delegates arbitrability, arbitrator, a neutral may need to decide if parties agreed to arbitrate their dispute by applying the UCC Battle of the Forms principle. And I expect to see further development of that law over the next, say, 12 to 18 months.
This is Jim. I will highlight one trend that I think is going to mark the future of technology transaction disputes, and that is the increasing importance of intellectual property to technology transactions, particularly with the emergence of artificial intelligence, robotics technologies, and related technologies. This is giving rise to collaborative ventures, and in these collaborative ventures, the intellectual property is becoming more and more important. And what that means, of course, is that disputes arising from the ventures are going to focus on intellectual property, all of which underscores the importance of paying close attention to the drafting of the dispute resolution clause in these types of ventures.
We one more clause that came in. I'm not sure if anyone would like to, maybe Jim, you'd like to take a shot at this also, on thoughts on mediation versus arbitration in technology transactions.
Sure. There are two factors that go into answering that question. The first is the quality of the mediator. If you have an effective and experienced mediator, I am very supportive of mediation as an initial step, a precondition to arbitration, but that's subject to my second factor, which is timing. Especially in the intellectual property area, the timing of the dispute is such that the IP owner in particular is not willing to go through a lengthy mediation process, but will need immediate relief, usually in the form of an injunction. So subject to that caveat, the need for immediate relief, particularly in intellectual property cases, mediation is an option that I think the parties should explore before resorting to formal dispute resolution procedures, because that enhances the likelihood that the commercial relationship can be preserved.
Thank you, Jim. Any other thoughts from a panelist before we wrap it up?
Brad, I noted that we had several. I'm sorry. I know we have several questions that we don't have time to get to. Perhaps we can offer to reply to those listeners directly by email.
Absolutely. Yes, and thank you for your questions. But for the fact that we've gotten to the top of the hour, we could go on with a few more of these questions, which are interesting questions. We will respond by email to all of the questions that have come in, and we do thank you for your. This wraps up today's program, and on behalf of me and Jim and Sarah and Miles, thank you very much for your time. We very much hope you found this program useful. We have 3 final housekeeping items. First, a recording and link to the materials for the program will be distributed by email to you in the next day or 2. Second, if you're applying for CLE credit, please note that the certificates of attendance will be distributed within 30 days of the program date. So if it doesn't bounce back right away, Be patient, it will come within 30 days. And then third, please watch your inbox for invitations to future programs. We've had a long-running webinar series and intend to continue it. If you have topic ideas or you want to receive invitations to future programs and are not on our mailing list, please email us at techtransactions@mayorbrown.com. Thank you very much for participating. This concludes our webinar.